Good morning, everyone, and welcome to Compassionate Chats. I'm Tanys Coughlan from My Place Home Care, and I am joined today by my co-host, Heidi Gagne.
Hello.
Welcome, Heidi. And we have a special guest today, Scott Pommerville. Welcome, Scott.
Thank you for having me.
It's an honor to have you. So why don't you tell people a little bit about what you do, Scott? That'll get us started.
So my name's Scott Pommerville. I'm a lawyer with Brazos Seller Law here in Ottawa. I practice in the area of estate planning, wills and estates, powers of attorney, and that area, which is applicable to today's discussion, but also corporate work and business law. Before we get going, though, just so I'm compliant with my law society obligations, I'll just say that I am a lawyer. However, I am not your lawyer, and nothing discussed or shared today should be considered legal advice or create a solicitor-client relationship. The information I'm going to provide is for general information purposes only and should not be relied upon as a specific advice for your situation. And you should always consult a qualified lawyer regarding your estate plan, powers of attorney needs, or any other legal matters to ensure your unique circumstances are properly addressed. But other than that, I would be happy to answer all the questions.
Awesome. Thank you.
That's wonderful. So I guess the first thing I would love to know is, what is a power of attorney? And how do you figure out who your power of attorney is, and how do you go about getting one?
So a power of attorney, there's two kinds. So the first would be your continuing power of attorney, which deals with financial matters.
Okay.
So if you become incapacitated, which would be determined by a medical professional, so you can't manage your own affairs, typically that occurs, let's say, for example, you're diagnosed with MS or dementia, ALS, something like that. It's not as though you're deemed incapacitated upon the diagnosis. It's only once you reach a certain stage of that disease where you become incapacitated. So you can't manage your own affairs. And so a medical professional will determine that and then write that you are incapacitated, and then your power of attorney is invoked. Okay. So there's two kinds. There's the continuing power of attorney, which again is for financial needs and matters. So your power of attorney would be responsible for making sure that there's enough money for your medical needs, so paying for at-home care or care at a facility, sort of the necessities of life, lodging, food, clothing, that sort of thing. They'd also be responsible for making sure that your taxes are filed every year. You're getting the proper tax grants or deductions, and then coordinating with either your financial advisor or your financial institution to make sure that there's enough liquidity in the bank in order to meet those financial needs. And then the second one is your power of attorney for personal care, which deals with medical decisions. So that your power of attorney, again, with the advice of your medical professional, your doctor, they would make decisions based on your medical needs. Because again, you're incapacitated, you can't make those. So then how do you go about getting a power of attorney? You should speak with a lawyer, because everyone's medical needs or continuing power of attorney matters are unique. But a lawyer can draft those up for you. And then when we talk about a power of attorney, who should be the power of attorney? My standard advice is you should have a power of attorney, ideally who lives in the same city as you. Okay. And that just is for practical reasons. It's easier for them to go to the bank, go to your financial institution, go to your financial advisor's office to sign paperwork and withdraw funds, etc. If you don't have somebody who's in the city, within the province is probably next best. And then after that, out of province. And then lastly, we don't like to do it, but if somebody's out of country as your power of attorney, that would be kind of the last rung on the tier. Similarly, when it comes to medical decisions, same thing. within the city, within the province, out of country. And again, it's for practical reasons of, if somebody's in Ottawa and they're your power of attorney, they can go to the hospital to discuss the matter with the doctors or what have you. So that's kind of the general advice of as to who, it's kind of a geographical question.
Right.
Power of attorney can be anyone. It could be your son or daughter, as long as they're the age of majority. It could be a family friend. It could be your lawyer. I have stood in as a power of attorney for clients in the past. We like to have there's always the first power of attorney, and then your alternate, and then sometimes another alternate. If you are going to appoint your lawyer or a professional in that sense, usually we would say, kind of the last option, but it is an option to do.
And how often should you review your power of attorney, and how easy is it to update it?
So a power of attorney, it shouldn't, it doesn't need to be reviewed as often as a will. But I'm sure we'll get into wills in a minute. When it comes to a power of attorney, it's something that you don't have to review as often. Typically, you should only review it if one of your powers of attorney has, moved away, is deceased, something like that, and then you can, or your relationship with your power of attorney has changed. Maybe it's irrevocably broken, and you no longer have that person in your life. Then you should certainly have a new power of attorney appointed.
Okay. And then you just go to the lawyer that did the original one and basically say, this is what I need to do. And do you need to have, so you obviously need the person who will be, do you need the person who will be the power of attorney to sign off on anything?
So two things. One, you don't necessarily have to go back to the same lawyer. Once you sign a new power of attorney, it will vitiate your old one. So it cancels it out. So, but typically you have a relationship with that lawyer, so you're most likely going to go back to them, but it's not a requirement to use the same lawyer. And then, sorry, the second part of the question.
Oh, no. Does the power of attorney, do they need to sign off on it?
No, but certainly you want to make sure that you've told someone,
that
you're going to use them as your power of attorney, because you want to make sure that they are willing to stand in as a power of attorney and not just be surprised when they get a call from the hospital that they're your power of attorney.
That makes sense.
So just check with them, and as long as they say, yeah, I'm willing to, then on the document we would put them in as the power of attorney, and then you as the individual would sign that power of attorney, and then it's witnessed typically by your lawyer, and then a clerk or someone else in our office, but it's witnessed by two individuals.
Okay. And a power of attorney, those are pretty much standard. They don't have, do you have leeway to adjust anything, or are they just standard, continue?
Yeah, I mean, I hate
personal care.
I hate to use the word standard when it comes to legal agreements, but their broad strokes is most of them will be similar and touch on all of the matters that have been raised, either through statute or previous case law, and they're updated from time to time. But yeah, I mean, from speaking in a broad sense, they're mostly, they'll all touch on the broad points as to what the powers that the power of attorney has to make decisions, etc.
Okay.
Well, and I would think that, you're speaking to making sure you let them know. You want to make sure you're having a conversation with them about what your wishes are, I would think as well, right?
Right.
In terms of that.
Correct. Yeah. So, I mean, typically that's why you see it's mostly family member first. And then, and then after that, it's usually either another family member or friend. And then lastly, it's usually if a lawyer is being appointed as well. Unless you've had, a 30, 40-year relationship with that lawyer, and they know you just as well as your family does.
Mm-hmm.
Right. And then, so power of attorney is able to make decisions when you become incapacitated and unable to make them yourself. So what about, what is the difference between a living will and a will then? because that's kind of like how you want everything dispersed once you've passed. But what's the difference between a living will and a will?
Well, so a will is something that deals with your assets once you pass away, right?
Okay.
So whether it's the sale of your, the division of assets between the beneficiaries, whatever that division might be, specific bequests, whether there's a trust in place for a young child who's not age of majority, whether there's a trust in place for even a child who has reached the age of majority, but maybe as a parent you're going, I don't think
not ready to give them that much money.
Yeah, like they're not mature enough to deal with this, and so
Right.
we can put it into a trust that is paid out over a certain amount of time, or has certain benchmarks that once the person reaches, they can draw something from the trust. So that's, and again, I'm sure we'll get into a deeper dive on wills. When it comes to a living will, what that is really it's specifying what medical treatment you would want or not want,
Okay.
such as resuscitation, ventilation, life support, in the event of incapacitation, which kind of then I know eventually it's a discussion we might as well jump into now, but typically that leads into the conversation around medical assistance in dying,
Right.
and what individuals would like if they are incapacitated to such an extent that that maybe they're only alive due to a machine,
Right.
other, as we call it, heroic measures.
Mm-hmm.
Wow. Okay. And how again, a living will you can update at any time as well. Is that
Yeah,
a
you can always
process to update?
same thing. I call your lawyer, call a different lawyer, but you can always update it as long as you have capacity.
Right.
Right. So with your wills, powers of attorney, living will, you can change them every day if you'd want it. It's not financially advisable to do it every day.
Yeah.
But you can, in theory, you could change it weekly, monthly, year. You can change it as many times as you'd like. Realistically, that's not going to occur.
Right.
But at this, I'm being a bit hyperbolic, but at the end of the day, you can change it as long as you have capacity. Right?
Okay.
So once you become incapacitated, you can then no longer change your will or your powers of attorney or living will. And your lawyer at the time when you're signing those documents will go through a checklist to ensure that you, one, have capacity, as we're all required to do by the Law Society, and we do continued professional development every year to ensure we're up to date on how to identify if somebody has capacity.
Okay.
And then the next would be that you're signing those wills and powers of attorney, et cetera, through without undue influence or duress, and you're doing it out of your own volition, right? And so that's why, even if you're your son or daughter and you're bringing your elderly mom or dad to the lawyer's office, and they might have physical mobility issues, it's kind of one of those things of once you get mom or dad into the boardroom with the lawyer will ask you to leave the room because it has to be done just between the lawyer and the testator, and to ensure that there is no undue influence, that they're doing it out of their own free will and volition and those sorts of things. And then we go through our capacity assessment checklists.
Wow. Have you ever experienced where you're like, yeah, that you don't want to do this? You're like, how do you deal with that? Like, how do you say,
Well,
I'm sorry, your mom's not signing these changes because she doesn't want to? Like, how?
Well, it's always, it's a delicate dance. Every family has their own dynamics.
Right.
But certainly in my years of practice, I've seen it a couple of times where I've had concern about capacity for clients, and have we go through a further sort of assessment to ensure that they have the capacity to do so. And then when it comes to undue influence, certainly I've seen it a few times, and there are ways to address it. But you want to make sure that as somebody who's selecting a lawyer to do these documents for you, that they understand this isn't just a come in, sign this standard will or power of attorney and get you in and out as quick as possible and pay my bill and see you later, right? Today, in today's day and age, even if you have two parents who work for the federal government or the provincial government, they bought their house in the 1970s or early 80s and are retired and have no other savings other than their pension. Right. That would be quote unquote, like a small estate by, kind of subjective standards. But it's,
He seems still frozen.
Oh dear, we have some technical issues.
I do. So it's fascinating what he's saying about the capacity piece. I know one of the positions I was working in, we had to have capacity before we could, take the applications, for instance, for long-term care and that kind of thing.
Oh, really?
So, yeah. So capacity is it's important. Yeah.
Yeah. So there must be some kind of special training out there for people to determine, because I feel like it's a very subjective thing. And we have a lot of clients who have dementia, and we tend to, how soon do you have to be careful of their capacity? And it's just that one day they could be fine. They seem fine and everything. And then the next day they're not.
Yeah.
It seems like it's almost like when you're in your 40s and 50s, you need to start doing this kind of stuff and getting it at least written down and started, and then update when necessary. And I'm totally like saying that, and not in my case at all. Like I don't have a will and I don't have a power of attorney, and I keep saying I really need to do this. So hopefully when we can get Scott back on, I'm looking forward to knowing whether there's a simple way to get something done, at least to protect yourself a little bit before you can, afford the cost of the lawyer to do all the paperwork. Because that's a huge factor for so many people, is that cost. And until you're forced to do it, most of us will just kind of go, we'll see what happens.
A will versus food on your table. Yeah.
And right? that's a real choice that people have to make right now. Like, I know that's a choice that I have to make. Like, okay, I need my car to get around and I need to pay for my car. So car payment and food versus getting my future that I'm not even thinking about, but I'm thinking about settled. Yeah. So it's a very difficult position to be in. So I'm hoping that there are some more kind of something that you can get off the internet where you can then complete it and at least have something started, and and find a lawyer that will make it official for you.
Yeah. So, well, and I think you can have it signed by notaries and stuff if in a pinch, but you do want to make sure that a lawyer takes a look at it. I think in the big scheme of thing, but I think that you can have something written down and sign it. It shows intent at least. Right. So if it were to be questioned at all, at least you'd have some intent written. Mm-hmm. If you have it notarized
and talking to people too. Like, I know I have that conversation with my mom now of like, what do you want? I'm her power of attorney and the executor of her estate. So, what is it that you want? We have a good relationship. There's no animosity. There's no negativity or anything like that. And I have no problems in doing what her wishes are. Yeah. But it's also having that conversation, which is difficult in itself.
Indeed.
And you always think of it at the worst possible time. I mean, my mom and I were talking about it when we were at a funeral. And I'm like, yeah, Mom, what do you want? I mean, like what are your wishes? And, and I think my parents are having more of that conversation now together, as well as to me and my sister. But my sister lives very far away. She's out of the country. So, I mean, this kind of stuff will end up falling on my shoulders for the most part, as the only daughter in the area. Is he back?
Yeah. No. But as Scott was saying, it's easier if you're in the same vicinity, the same area.
Yeah. And it makes it so much easier and less hassle on me. Because I am going to have to split my time. I'm fully aware of that. They only live half an hour away. So, I mean, it's the same as going to the grocery store for me.
Yeah.
So but it's also hard to think about that. So.
It is. It's not, I know when I was a teenager, we lost like 3 of my grandparents within a very short period of time. So it became very in my face at that age. So I've had that stuff in place for a while now, I think, because of all of that, but it is tough to think about and to sort of move into acceptance that this will happen to all of us, because, it is one of those things that none of us can avoid. So, yeah, as much as it's a difficult topic for people and we don't want to, move into acceptance of it, but it's still there, right? It's still a topic.
It's hard. And then you bring in things like maid to it.
Yeah.
And then that's a whole other, I personally struggle with that. Like I keep thinking
that, and just for the audience, in case you didn't hear that earlier, it's medically assisted induced death, I believe.
Yeah.
So that's what we're talking about with maid. Yeah.
So I find it very difficult for me thinking what could possibly happen to me that would have me think about that, because I've been a very lucky person. I'm very healthy. Okay, right now I have a bit of a cold, but for the most part, I'm a very healthy person, and my family on both sides have been relatively healthy, and there haven't been massive medical issues, and so I haven't come across it personally. I haven't seen it up close, at least when I have been old enough to recognize and understand what's going on. I know there has been some breast cancer and ovarian cancer in both sides of my family, but again, I was super young during that time, and I was not included in any kind of conversation about that sort of thing.
Yeah.
But to me, I find it very scary to be at that point where I would think about it.
Well, and I think it really depends. I mean, the aspect of capacity that we were talking about earlier certainly comes into play there. There's a lot of stuff around it. So I do have a family member that's considering it. And, she's had to have a waiting period, a 3-month waiting period. She has to have monthly check-ins, between then and when she decides her date is, all of those things. And so it's quite a process. Like, it's not something you just go in and sign something and it's done. Like and you have medical assistance, like through the whole process, medical evaluation about where you're at, psychologically, physically, all of that stuff. So the capacity thing, if you're going to make a decision about that, you have to be capable of making that decision at this point. That's where I would have loved to have Scott's take on that, because I think there's been some shifting in that. He was mentioning some changes there that are sort of being talked about anyway around that. So,
and political parties in power can affect that. And we are kind of right now at the cusp of a very interesting political potential change.
Yes.
Shall we say? We don't talk about politics here, but sometimes politics do affect
it does.
the things that we deal with. And, so so I think we'll probably see about inviting Scott on again with no technical difficulties, because I think he has a lot of value in what he says. And pardon me, just a second, boy.
Yeah, we'll invite him back and see if he can add some more light to those things. Unfortunately, when we do live, we get technical issues that come about.
But
and
luckily,
so
Tanys, you and I can talk on and on, so it's all
we
good.
can.
We just don't have the official power to or knowledge of these things.
Here we are.
Is he back?
He's back.
Yay!
Hello.
I have to go. I guess there must be some work in the neighborhood on the.
Oh, that's okay. It happens.
No worries.
Apologies.
No, that's fine. We were just kind of chatting about our own experiences, as with power attorney and planning and all that. But we did kind of touch on MAID and the kind of how it's, shall we call it, fluid, based on I guess you were saying which organization was talking about changes to it?
Well, they were recommending changes, I think.
Recommending
what he was
changes.
saying. But we still have as a country, we have, I think.
Yeah, so for MAID, so just to recap, yeah, your living will deal with those questions of how you want to be treated when you have an incapacitation,
Okay.
necessities of life and that sort of thing. And so the way we operate is we kind of provide 4 different options as to how you'd want to have your living will drafted, to account for things such as ALS. At some point, it's a terrible disease. At some point, you're going to be incapacitated, but still lucid,
Right.
but talk, unable to eat. Is that a way you want to live or not? Right.
Right.
I've had clients redo their wills mere weeks before deciding to exercise MAID, because they're in liver failure, or they have ALS and they've made peace with their life, and they've said their goodbyes to everyone, but they want to be able to do it on their own accord, on their own terms. So when it comes to MAID, as far as from a legal perspective goes, it's a bit of a political hot potato, because
I would imagine.
Change. Certainly, the Supreme Court of Canada has made its decisions and recommendations to the Liberal government over the years. Every time there's been a challenge, obviously, we're in the middle of an election cycle.
Yeah.
With everything that's going on in the world, it doesn't seem to be at the top of the political list as to
right.
Going to be that the law will change around it, even if there's a Liberal government, or if there's a Conservative government. So it's not really a hot button political issue. So typically when they're not hot button political issues, they're not really addressed.
Right.
Yeah.
So we just have to continue on as if it's business as usual.
Everything is the same.
So right now, you do still have the option of MAID. You obviously do have to consult your medical professional, and they will make a determination. But I've had clients in the past do it because of various diseases that they've been diagnosed with that are incurable.
Yeah.
And that's, then what you're referencing is, I believe it was yesterday, the United Nations, one of their departments had made a comment about Canada and the ability for MAID to be used by people who don't suffer from chronic illness, or physical ailment, or sort of an ALS, a dementia, that sort of thing. And so again, when the UN raises these issues, is there going to be any political will to address them?
Right.
A question that I don't have an answer to.
Of course, yeah.
Yeah.
The UN has made recommendations to the Canadian government as to their practices around other areas, and so far the Canadian government has ignored United Nations human rights. So it depends. It's political. We just have a current environment. Not to say that it won't change in the future. It's just an answer I don't have.
Right. Mm-hmm. I mean, I think that we have, as a country, the ability to make that decision for ourselves. I think that's fantastic. I mean, Tanys and I were just chatting about it, and I struggle with, I've never been in a position or seen a family member or a loved one be in a position of so much pain, of so much, knowing that you're going to probably linger for way longer than you really want to have that. But so I find it difficult myself because I've never had to experience it. But the fact that it's available, I think, is fantastic. And it just shows that Canada is, we care about our people and they're allowed to make their own decisions, which I think is fantastic. There's so many other debates we could get into that I think Canada is great about, because they allow us to make these decisions for ourselves. And as a woman, women have not always been given the right to make these decisions. So I think it's great. And it kind of frustrates me when those things might be changed.
Well, I think that it's important to understand that it's not just for anyone too. I mean, we spoke, while you were off, Scott, we spoke about the fact that I have a family member that's considering it, and that it's quite a process with the doctors. It's not something you can just do. You know what I mean? It's months of wait time to make sure that you are of sound mind and all of that stuff. Is that correct, Scott? Is that what your experience has been?
Yeah, I mean, it's not, it's not a rubber stamp. It's not an easy process to get through. I think as a lawyer, it's just one of those, we don't pontificate or decide after our clients. It's if our client seeks it, they seek it. Our goal is to just advise them as to, if you are seeking MAID, it's probably a very good idea to revisit your wills just one last time, make sure that it's squared away the way you would like it, obviously prior to your passing by MAID. But as far as the legal changes around MAID, like I say, it's not, I don't want to say it's not settled law, but certainly there's a lot of politics around it.
Right.
And that just, that is what it is. I mean, politics is an ugly business sometimes. And it just depends.
So if it's something that you're thinking about, then you really need to advocate for yourself and stay firm if it is really something that.
Yeah, I mean, as long as the law still allows it, it's right. For an individual or clients from a legal perspective, it's just one of those things of, I always advise clients that if that is the road that they're going to go down, just to triple check their estate plan and all squared away before they're passing.
Yeah. Okay, so Scott, can we just quickly, I know we only have a few minutes left because you were technical difficulties, but what is the minimum? Like Tanys and I were talking about this. I am like, I have to pay a car payment and food or set up a will. These are my options. What can the regular Joe or Joanne do to at least get something legally done that might not cost a week's worth of groceries or more, so that at least they're somewhat protected?
Yeah, I mean,
and I'm going to pay attention really well because it's me.
We got lots. Don't worry about that. What I would say is it's really case specific, and right. I'll put it in this way, right? A number of years ago, prior to my start of practice, the Ontario government put together, quote unquote, a standard will and a standard power of attorney in Ontario. As long as you follow the witnesses and the fact that You can't have a beneficiary witness a will.
Right.
If you have quote unquote a simple estate, you might not have any property, you don't have a lot of means, that's probably something that could likely, deal with your estate so you don't die intestate, which means without a will.
Right.
But again, that's a small segment of society. Then there's a small segment of society that have businesses, right? Private businesses. So with someone like that, you'd want to have your general will, which deals with your personal property. It will deal with how you want your estate to be divided. So does your house go to one of your children, or is it put, and then put into the estate, and the residue of the estate is divided in equal shares, as we say, share alike. How many kids do you have, and how many grandkids do you have? And so, are we getting into a question of saying, okay, well, if Heidi is my daughter and she predeceases me, then I want Heidi's portion to go to her children, so then we're getting okay, well, we're going to divide the estate equally amongst my issue, which is a fancy term for saying children. And then if they, predecease me, then I want it to go to first piece, which is just an equal division amongst, Heidi's children. So,
right.
But then we get into question. So with someone like that, and then let's say I have a business. Okay, so I would want what's called a limited will. Some people call it secondary will, but limited will. And that will deal with how my private corporation is handled upon my death, right? So,
okay.
And there's questions of what kind of assets does the corporation own? Is there any retained earnings in the corporation? And then, kind of dealing with an accountant as to what the schedule is like to withdraw earnings from the corporation to limit the tax exposure. So that's where you can get into a much more complex estate plan.
Right.
And certainly there's questions of if I have children that have not reached the age of majority, are we getting into trusts? If I have a child with disabilities, okay, well, then do we have a Henson trust, which is just a trust for children with disabilities? But even if they're of the age of majority, perhaps you have a child in their 20s, but is autistic and doesn't function at a level above kind of a 10, 12-year-old.
Right.
So we want a Henson trust in place for them. So again, once you start to slice down these layers of an individual's personal, I don't want to say issues, but
situations and stuff. Yeah.
Yeah.
Well, then it gets very much more complex, right?
Right.
That's not even addressing the issue of today of, blended families,
right.
or the issue of, because when we talk about blended families, the other things we have to consider is, is there a separation agreement with your ex-spouse and requirements to obtain life insurance, or is there, living directives with respect to maintenance of an ex-spouse through a separation agreement. So again, these factors become involved, and then, it's kind of
right.
my past and I'm married and my new spouse has children. Do I want any of my estate to go to my new spouse? Do I want any of my estate to go to, her children? Because are they stepchildren? Have I adopted them? Were they of the age of majority, so 18 plus at the time of us getting together, and so I didn't adopt them? You can see how, we start.
It's so murky. It's so, so much.
And
that's the value of having a lawyer, right?
Yeah.
Well, and, to layer on top of that, we get certainly the advancements of science. And so, what if I divorce and then I repartner, but my partner has a child by a sperm donor through in vitro.
Right.
Right. So,
wow.
So it's just how to treat different matters. So that's why I don't like to say standard will or power. It would be wonderful if everyone, got married, had kids, had a house, and was married for 60 years until they passed, and there's no issues in the family at all.
Right. In your family.
It's just not reality.
It is not.
So yeah, I mean, there are options if you don't have any wealth or means. And then there's certainly, just like any service, because that's what lawyers are, we provide a service to our clients. It's a wide thing of, I'm sure you could have, there's lawyers that do it for very little money, all the way up to, very complex estate plans for, individuals worth tens of millions or hundreds of millions of dollars, and they're just not in the same stratosphere, right?
Right. Me with a mortgage that's not going to be paid off anytime soon, a biological daughter, a stepdaughter, debt. I could probably create one relatively simply.
Yeah, I mean, there's holograph wills where you can just draft it up yourself and, number the pages and make sure it's signed and dated and witnessed. It's just one of those things of, you get what you pay for.
Right.
Yeah.
Any other service or business that you attend. My best advice for clients is just make sure that it doesn't matter who you engage to be your lawyer to draft these estate plans or anything, but just make sure that they are aware of and have the expertise or background to really address your estate matters.
Right. So don't go to a family lawyer or something like that to do your estate planning. Try to find somebody that at least has the experience and the know-how to ask those questions.
Yeah,
that you've just mentioned. Things.
Yeah, I wouldn't. I would not use. I wouldn't go to an intellectual property lawyer to draft my estate plan, right?
Right.
I would at least try to find a lawyer who has a background in wills and estates. And after that, it's really, are you comfortable with the individual that's doing it? Sorry. And then, are you comfortable with, obviously, there's always a question of costs. And
yeah.
I always tell clients, cost really huge. Because, again, we're talking about what amounts to millions of dollars.
Mm-hmm.
That, would it be wise to say, okay, well, lawyer X is going to charge me $900 and lawyer Y is going to charge me $1,800? Is that a way to make your decision? I think made on. If you're comfortable with the individual, do they have the background and the experience? And then, and once you check those boxes,
sorry, you're breaking up a little, Scott, just so you know.
Yeah.
Way to do your
this is good. This is good information. So yeah. You want to be comfortable with the lawyer. You want them to have some ideas, some background in estate and will planning. And what was the other thing?
Just that they understand your needs. Right?
Yeah. And they understand your needs.
Right. Because life is complex.
Right.
Well, and it's beneficial to get to know a lawyer, right? One that does a lot of the regular stuff in terms of, your house and all of that stuff, because you've got to do things like that as well, right? Through a lawyer.
Mm-hmm.
Yeah.
So if you get to know somebody, they get to know your needs a little bit more.
And that's generally why you keep with a lawyer for a long time. But again, there's no there's no requirement to use, even if you're a child, there's no requirement for you to use your mom and dad's lawyer. You know,
Yeah.
Right.
Like,
Yeah.
no, it's just a thing to make sure who you're comfortable with. And the chat said, where I don't think, you know, cost should always be front of mind in this situation. Certainly, you know, when I go to the grocery store, yeah, cost is top of mind of, you know, buying berries and
Of course.
meat. But that's not, you know, that's like it's a transaction. Whereas this would be the cost to your estate. Now you'll never know it because you'll be dead. But the cost to your estate and the fraction, the fracturing of the family unit that can occur because you didn't take the time to properly will, whether it was, you know, you just picked the wrong lawyer, you were too about cost properly done. It costs the estate much more than the 1,000 would have decide upon. You know, I quite frequently appointed by the court.
Sorry, you're cutting out again.
Yeah.
Unfortunately.
Is that better?
That's a little better, I think.
That's a little better.
Yeah.
So, you know, I am appointed by the court to quite a number of estates.
Okay.
And,
yeah.
You know, or I'm appointed as part of beneficiaries are in litigation against each other. Resolution. You know, but that's not a good thing for your estate because
no.
Beneficiary is hiring their own lawyer to litigate, which is a cost. And then instead of, you know, a son or daughter being the executor, well, then now I'm being appointed. So then there's, you know, another layer of legal fees.
Cost.
Yeah.
Yeah, and cost. And, you know, it's not, so again, I think it's kind of, it'd be penny wise, pound foolish, you know, to not have it properly done at the start.
Right.
And then, you know, once you're deceased, it's better for your estate because it should, you know, it's not a guarantee, but it should be smoother, and then the costs are lower to the estate when it comes to your estate administrative tax. Did your lawyer provide you with the proper advice that you naming beneficiaries for your RRSP or your RIF or your TFSA, and ensure that you went and spoke with your financial advisor and made sure that the individual was named, not the estate, because again, you know, then it would be taxable by probate. So you know, you can see how
getting a lawyer is way better.
Yeah. Our conversation, I bore you to death, and that's why I'm super fun with parties. But other than that, it really should take the time to do it.
Yeah.
It's a cost, and obviously in today's environment, we're all very.
Yeah.
It's better to do it now and have it properly, whether you call me or a bar or a colleague.
Right.
It's always better to have it in place, properly done, than not work.
Well, and you mentioned the toll that it takes on the family too, if it's not done. I think that's you know, invaluable in terms of irreparable damage that could be done if it wasn't, right?
Yeah, I mean,
done properly.
Unfortunately, I see a lot of family fracture when the last woman, her dad passed away, but there's animus that is built up between, you know, son and daughter, whoever is the beneficiary, and it's usually because mom or dad or they're, you know, or they, they haven't been open with everyone as to how they would like their to go. So it's just
the communication factor is important in all of this, right? With the family to decrease angst later on. For sure.
I know my grandmother, when she was moving into a retirement home, she called her 3 daughters, and they literally went through the house and marked things that, okay, this is what we're not going to keep when we move into the retirement home, who wants what. And then when they moved into the retirement home, the one she was in Florida kind of progressed from like apartment living or like condo living, then apartment, and then assisted living. And, you kind of have to weed out stuff as you move through that. And she literally had dots on things underside. So, okay, this is for my oldest daughter. This is for my youngest daughter. And at the time I'm like, oh my God, that's very dark. But I'm like, I kind of want to do that. Like my parents, we're going to do that at my parents' house when my sister comes to visit. And we're going to go through everything and say, this is legit what we want and what they want us to have and all that kind of stuff, and take care of it now.
Well, you're making decisions then in a state where you're not emotionally charged.
Right. And you're not, you're not feeling, animosity. My sister lives in Hawaii, and I'm going to be we've talked about this before, I'm going to be dealing with a lot of things from my parents. Am I going to get stressed and say, hey, like, you haven't done anything. Why are you getting 50% of everything? I'm not like that. So, but I can see how families would be like that. There would be a lot of families that would have that kind of animosity.
So is that something you would recommend then, Scott, is making sure that people have a copy of the will, perhaps?
That's always a good conversation. So the way it typically works is that so the original always stays with the firm that drafted it, kept in a safe safekeeping, because you have to submit the original bill to court as part of the probate application or the some clients like to provide copies to their children or the beneficiaries. When you do pass, the beneficiaries do receive the section as to what they're entitled to, but they don't receive the balance of the will. It's always, again, it's the family dynamic of it. We advocate for sure are aware of what you will, like. There's no hard and fast rule of should give a copy of your will to the beneficiaries, because, for example, if again you're my daughter and I say, Heidi, here's a copy of my will, and it says you're getting 50% of the resident estate, but then over the coming years we have a falling out, and like through lifestyle choices, and no longer have a relationship, and I redraft my will, and then I pass away, you might come to court and challenge the new will by saying, look, Dad told me I was going to get 50%, and I want 50%, and then we're in litigation, and so it's the old saying is the best way to
we missed all of that. Sorry, Scott.
So, the best advice usually lawyers give is it depends, right? It just depends on personal circumstances. But the best advice for your viewers would be that you should contact a lawyer. You should engage them to get an estate plan, a living will, powers of attorney. And then, at least at a minimum, you have something in place so you won't die intestate. So again, without a will, because it's, again, dying intestate, it brings a whole new host of issues. Right. And then in communication with your beneficiary. Is there a list that's attached to the will that you've put together that says, the fine china goes to my daughter, and my wedding band goes to my son, and after that you guys can divide up whatever you want. So as far as personal household effects go, because that's the start of the fights, is the mental value of items from parents' home. So again, I think everyone should have a will, and I'm not naive to think that everyone will. Costly, there's costs involved, there's time involved. It's not really, something that people progress until they get even later in life, and they go, "Oh, geez, I don't have a will. I should really do it." And they're in their 60s.
Yeah.
And they say, when I ask them, "Well, why now?" And they go, "Oh, my friend just died."
Yeah.
Okay, but I always tell clients, even young people who are buying homes, and are engaged, once they buy a house and you're engaged, you should have a will. No, it's going to be a simple, quote unquote, estate or will or estate plan, but you should have one. When you have kids, you should have an estate plan. As you near retirement, you might want to revisit your estate plan. When you're in, you probably want to revisit your estate plan. If you're separated and you're divorced, again, you want to visit your estate plan. So it's just one of these things of estates can be very complex. They can be simple, but the best thing is to always have a will in place and your powers of attorney, and then a living will, to ensure that if something happens to you tomorrow, everybody in your life knows how your assets are going to be divided, how you want to be cared for medically, all of these.
Yeah, that's great.
Yeah,
that's great advice.
Great advice, and yes, I am going to listen. I will start doing all that.
Well, thank you so much for joining us today, Scott. I appreciate all of your advice.
And the extended time.
And yes.
You have to adapt, right?
Yeah.
That's right. We just have to go with the flow.
I appreciate the invite. As certainly, like I say to your speak with a lawyer, any member of the bar of the Law Society of Ontario. If you're listening in a different province, again, find a lawyer in your province, and highly recommend you stop delaying in doing it, and just have an estate plan put together. If you're unsure, at least in Ontario, as to who do I contact, I don't even know a wills and estates lawyer. You can always contact the Law Society of Ontario, and they have a referral service where they'll give you the names and numbers and contact information of lawyers in your area. Certainly with the advent of COVID, we can now do wills anywhere in the province. It's just Teams calls, and we can send the documents to you and then execute them while on a Teams call and that sort of thing, which is been the one of the good benefits of COVID is we're able to reach more people as lawyers but again, even if you're in Thunder Bay or Kirkland Lake and you don't know if there's a lawyer in town, that can just call the Law Society. They'll point you in the right direction. But
that's great advice.
You certainly should look.
And if you're looking to contact Scott, we did provide email to reach out to him if that is something that you are interested in working with him.
Hopefully you are.
Yeah. As long as my internet.
Yeah, as long as your internet's working.
Yeah, exactly.
Work from home today was not the right choice, because must be somebody outside working on the telephone poles.
Oh dear. Probably from the snow and slush from yesterday.
Yeah.
I appreciate the invite, and it's been a good conversation. Wills can be very complex, different think about, and I go and get yourself a will, find yourself a wills and estates lawyer, and you'll be able to sleep better at night knowing that if something happened, there is a plan. You're hopefully, when you pass, there's no fracturing of the family unit because everyone understands what mom and dad wanted. But, yeah.
Awesome. That's great. Thank you so much. Get your will. And and we wish you a wonderful day, everyone. Don't forget to come back and join us the last Friday of the month, and we'll see you then. Take care.
Thank you, Scott.
Thank you.
Scott.